It's going now.
Some little cough. Sorry. Thank you.
It's going now.
All right, we may proceed, Trina.
The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice presiding.
And will the courtroom clerk please call the case?
This is Supreme Court case number CRA22-001, People of Guam Plaintiff Appellee versus Normandy Ilagan, Penaflorida, Defendant Appellant. Appearing for the Defendant Appellant is Attorney Brian E. Kigaris. Appearing for the Plaintiff Appellee is Attorney Woodrow D. Pengelly. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Kigaris reserves 5 minutes.
Thank you, Trina, and good morning, counsel. And Mr. Kegger, you may proceed.
Thank you, Your Honor. Good morning, Chief Justice Carbolito, Justice Merriman, and Justice Torres. May it please the court. This matter comes from CF 734-18 or Criminal Appeal 22 CRA 22-01 in the matter of the People of Guam versus Normandy Ilagan, Penaflorida. In this matter, Mr. Penaflorida was indicted on December 18th, 2018 on 2 charges of first degree. The first charge, was second degree criminal sexual conduct as a first degree felony. The second charge was a 4th degree criminal sexual conduct as a misdemeanor. In today's hearing for the appeal, we will be raising only one issue before the court in this morning. And basically what that is going to be is the insufficiency of the evidence, Your Honors. More specifically, that the government had failed to prove and did not satisfy that the force or coercion element of the 4th degree criminal sexual conduct was met.
Mr. Kirgis, I just want to, confirm, obviously, when we review the sufficiency of the evidence to support a conviction, in this case, whether it would reasonably support a finding of guilt beyond a reasonable doubt with the jury having made its determination, we look at the evidence in the light most favorable to the prosecution, and whether any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And it's a very deferential, highly deferential standard of review.
Yes, Your Honor. And I was going to say, during the trial court, the defendant did ask for a motion for acquittal on both charges, which was denied. And then under People v. George, we do understand as the defense that it is looked at most favorable in the light of the prosecution, and it is a very tough burden to overcome that situation, and we definitely understand that, Your Honor. We still contend that they did not at trial prove that force or coercion was used under the statute for 4th degree criminal sexual conduct. That statute reads in pertinent part to our discussion today that a person is guilty of criminal sexual conduct in the 4th degree if he or she engages in sexual contact with another person, and if either of the following circumstances exist. Force or coercion is used to accomplish the sexual contact. Now, throughout the testimony that the alleged victim had given, there was testimony that there was a hug, and that is something that is not being disputed. There was a hug, and it was only the force that is inherent in a normal type of hug. It wasn't something that was that was overly aggressive or something that was overly done.
I mean, normally when you hug a person, you're grabbing them around the back. You're not reaching down to touch their buttocks. And there were other circumstances besides just a simple hug. I mean, even if it was in the case, there was his statement to her that she looked sexy. I thought that was also there. There was also the, don't tell your dad, which seemed to suggest that he knew that what he was doing wasn't necessarily appropriate. And then I believe there was some testimony that he kissed her on the lips.
Yes, Your Honor. So what we'll start with is the actual hug. There was some dispute about how long the hug actually took place, where the hug actually took place. The alleged victim indicates that it was the upper buttock area, somewhere around there. Mr. Penaflorida's statement that came into evidence indicated that it was the lower back area. And he also indicated in his statement, which was read into evidence, that it was 5 seconds, 6 seconds. It wasn't the 20 to 30 seconds that the alleged victim.
But isn't that the jury resolving the disputes and evaluating the credibility and accepting the story? I mean, if this was undisputed evidence from both of them, it was 5 seconds, it was on the back, we might have a different case, but that's not what we have here. We have one witness testifying to certain events. And in the fact that you're bringing up these disparities in the testimony suggests that was really something the jury evaluated.
Yes, Your Honor. Now I also want to go back to the fourth degree CSC statute, which says force or coercion is needed. And there is no force or coercion in this case. The alleged victim was behind a locked screen door before any of this occurred. She met him through a locked screen door. She is the one that then opened the door and went outside the house, and then that is where the hug occurred. So it's just it's something that happens within an inherent hug, a mutual hug.
Well, the government points out that if you look at the definitions in 2510, the force or coercion, and that list of circumstances, as the definition says, it's not limited to those circumstances. The government points out that the element of surprise is possible because he ended up touching her buttocks, and it was in a surreptitious approach, like, I'm just going to come and hug you, and then grabbed her buttocks. And so there was that element of surprise. And so therefore you still have the force or coercion element found through definition under 9 GCA 25.10E, that he was, the element of surprise.
Yes, Your Honor. According to 25.10 A2AE, it does state that if force or coercion to include when the actor overcomes the victim through actual application of physical force or through concealment or by element of surprise is able to overcome the victim. It is our contention that
Mr. Tegger, let me just I want to, excuse me for interrupting you, but I just want to first focus on the actual force, because we understand that there are various ways, and the government argues that there are 3 ways in which to satisfy the force or coercion, but you started with the actual force. And I'm more interested in the standard that we may want to try and adopt in reference to the actual force. And the case most on point for me is that Michigan Court of Appeals case, People versus Witt. And in that case, we had the defendant touched the victim on top of and inside the victim's shorts. And the language that intrigues me in that case, when in reference to the Court of Appeals defining what actual force means there, is where to seize control of the victim in a manner to facilitate the accomplishment of the sexual act without regard to the victim's wishes. And your argument is that, you know, the mere touching is not sufficient to constitute the actual force. But I'm wanting to know your thinking, where we have someone who's actually seizing control, and you could say whether it's 5 or 6 seconds or 20 to 30, and as just Story said, you know, we view the evidence in most in favor of the government in reference to the weighing of the evidence that the jury did, and the accomplishment of the sexual act and it's without regard to the victim's wishes. And in that particular case, the Court of Appeals held that there was actual force that occurred. And again, the facts is he just put his hand over the victim's the front part of the victim's shorts and then into his shorts. And there, the court applying that standard said that that was sufficient, and similar CSC 4 definition as our case. So how do you distinguish that case with the facts of this case?
Yes, Your Honor. So according to that case, it sounds like there was an overact that occurred to where it was inside the shorts. This was outside of the shorts, where the hand was just resting on the lower back or the upper buttock. There was no overact. I do know a lot of the Michigan appeals courts, they deal with overt acts, either a pinching, a grabbing, a squeezing, a rubbing, something that where there is an overt act that occurs that needs to be done. In this instance, all it was a resting of the hand on the upper buttock, excuse me, or the lower back area of the alleged victim. There was no testimony that she indicated that, oh, he pinched me, or he was rubbing my upper buttock or my back or anything of that nature. No squeezing, no grabbing, nothing to have such an overact. It was a hug, and it's the typical force that's used in an inherent hug. So that's how I would distinguish from that case.
So your the emphasis then in reference to your argument is the fact that he put his hand inside the victim's shorts, that made it such that he was able to seize control of the victim to accomplish the act. I mean, and so you're saying that just the mere fact that the defendant put his hands on the defendant's buttocks, and if it was for a period of time, and we're saying that it didn't really matter in reference to the victim's wishes, it is just to overcome overcome her, I guess, her actions, that would that be sufficient? And you're saying that is not, that there needs to be some physical force more than just the placing of the hands on her buttocks?
Yes, Your Honor, that would be my contention. Is like I said, most of the Michigan Court of Appeals that we've focused on, and that the Attorney General has focused on, and I know they used People versus Primo quite a bit in their appeal, or in their reply, excuse me, and that does have the overt act of an actual pinch. And that is what clearly separates these two cases. I mean, this could be going down such a slippery slope. If you're walking in a crowded area and you rub up against someone's buttock are we now looking at a 4th degree CSC because this accidentally happened? If you're on a bus,
Well, I think that's a little different. That's, the accidental touching, I think, it could be clearly distinguished from someone who hugs the person and is in control of that person's movement, and in this particular case, he held her, whether it's 5 or 6 seconds or 20 or 30 seconds, and she felt that she was not in control of her own movement. That's a little different from someone accidentally, coming on contact with someone in the streets.
Yeah, sure. And I do concede that they're a little different, but where does it stop, I guess, is where.
But even in this case, I mean, why isn't the hug is one thing, and then the movement of the hand down to the buttocks constitute the use of force to accomplish that contact. So that's a different application of force than the initial hug. So it's something inherent from the original, something different and not inherent in the original act.
So yes, Your Honor. I see that. See what you're saying is that the act of possibly him moving his hand down could be the inherent act or overt
the additional act that, yeah.
Yes, and so we still contend that he was just resting his hand there. That the evidence did show, and that she did testify also to he just rested his hand there. There once again that it was just resting there. It wasn't moving around. It wasn't doing anything. It might have moved slightly, but it wasn't that overt act of pinching or grabbing or squeezing or doing something like in Primo or even in Patterson, where the defendant grabbed the victim's hand and placed it on the genital area outside of the victim's underwear, but removed it when she turned away. They didn't find that was force or coercion. And so there has to be more, is what I'm saying, than just a possibility of arresting your hand close to the buttock. There has to be the pinching. There has to be the grabbing. There has to be more of the overt act than the possibility of just putting your hand there. And the alleged victim in this matter, she, as Patterson said, the alleged victim in Patterson moved away, turned around, did something. She didn't say stop it. She didn't say anything. Not only did she not say anything, move, she went in for a kiss after the alleged after the hug. I believe it was described at trial as beso beso. So the kiss on the cheek. And so to say
which he then kissed her on the lips, right, at that moment. And so, even if we accept, let's say we accept your theory that there was no force, no additional force, and when I look at the Berlin case and the Patterson case, both of those seem to have been decided before Michigan statute was amended. CSC 4 statute was amended to add this concealment and the element of surprise, which the government points out is another basis by which the jury could have found that he accomplished a 4th degree CSC. So, even if we accept that aspect, saying, okay, there was no force used to accomplish the sexual contact, you still have this other problem of the element of surprise and using the definition under for, and as not the actual force used within the definition of 25.10A, but under E, wherein he through concealment or element of surprise is able to overcome the victim.
Yes, Your Honor. At this point, we would contend that there wasn't an element of surprise. She, and this goes more to the Eller case, where the defendant in that matter came up from behind, went through the shorts, that was surprised. She saw him. They were talking through the screen door. They were face to face. She went in for a hug as well. This was not surprise, or she knew the hug was coming. And then, like I said, she couldn't have. It didn't seem like she was in that much shock because she did go in for beso afterwards. She didn't say, anywhere, stop. This is making me uncomfortable. Or move his hand just a little bit up, or anything of that nature. So with the Eller case, that is the surprise. That is coming up from behind, and touching them.
What about Mr. Kager's the testimony of the victim here that she was just in total shock. This is her relative who she opened the door for, that thought that there was just going to be a respectful greeting in the Chamorro culture, and this someone just he comes up, hugs her, holds her buttocks, and her testimony, she just froze. I mean, it was totally unexpected. So you're saying that the element of surprise has to come from the rear, and you can't have the element of surprise in a face-to-face confrontation. And is that what you're suggesting?
No, I'm not suggesting that it can't be an element that can happen face-to-face or something to that nature. But in this situation, she did know that that a hug was going to happen, and we still are under the assumption that or the contention that this was a hug, and it's just the normal type of hug, and that was it. And she knew a hug was coming.
So part of the normal hug is to hold someone's buttocks for, even if we were to view it in along the lines of his testimony, 5 to 6 seconds, and without any type of warning that this is going to happen, that this is a normal way of greeting someone in order to pay proper respect.
Your Honor, he wasn't holding, it was arresting. It was kind of just there. Once again, that's the overt act. There was no holding or grabbing or pinching or rubbing or anything of that nature. So there wasn't a hold. It was just resting right around that area.
But in looking at force or coercion, don't we also look at the totality of the circumstances? And so, you just don't have the hug, even if the hug went down to the buttocks for a short period of time and the disagreement that was there. But what about all the other factors? Him telling her, don't tell your dad, I think you look sexy. Aren't those supposed to be considered, or they're not considered? I mean,
yes, Your Honor, and they can be considered. And it did come out in his written statement and in the testimony that was his written statement that was shared. Was he indicated that he was joking, and they had joked around like this before. And as far as not telling his father, this is a very contentious family relationship. to call them family it's very loosely. The second degree CSC was charged as blood and affinity, and he was found not guilty of that. So the family connection there is very tenuous at best. The mother of Mr. Penaflorida was with the grandfather of the alleged victim, who had passed away many years before. I believe he passed away in 2016 or 2017. And so that also breaks the familial, any kind of familial problem that we would have there, because they weren't family at that point in time. And this court also even it cites Commonwealth v. Ables, where an uncle-niece relationship alone won't suffice to find forcible compulsion. And so even if the court was to say, okay, this is an uncle-niece relationship, that's still not enough. There needs to be more. And alleged victim, like I said, she opened the door. It was a locked door. She's the one that opened the door. She's the one that went outside. She's the one that didn't do those things, and we're not blaming her for anything, but she didn't say stop. She didn't go back inside. She didn't say any of these things, which is needed in some of the Michigan Court of Appeals decisions, is to retreat or try and retreat or say stop or do these type of things. And furthermore, we'll go to the Primo case again. That was a teacher-student relationship within the classroom. This is nowhere near that type of coercion that would allow for something like that. This is used to be I don't even know if family member is the right word, but they know each other.
So you have a little over 4 minutes. Or do you wish to reserve your remaining time, Mr. Kegeris?
Yes, Your Honor.
All right. So at this time, Mr. Pengelly, you are recognized.
Thank you, Mr. Chief Justice, Justice Torres, Justice Merriman, Woodrow Pengelly, on behalf of the government, and may it please the court. Your Honor, I agree with Mr. Kegeris. The issues in this case are fairly straightforward. Was there enough force or coercion to sustain the jury's verdict? As this court knows and talked about previously, the burden here is construing all the evidence in the light most favorable to the government. Could any rational trier of fact believe that all elements of force of fourth degree CSC to include force or coercion are satisfied? And it is our position that there was enough evidence to satisfy this element for a number of different reasons. Force or coercion is defined by illustration in the statute with a number of different ways. However, those are only illustrative, but specifically there was evidence of surprise through the surreptitious approach. There's evidence of actual force, and there's evidence in the unenumerated totality of circumstances based on the relationship and other factors. In this case, the defendant, who, whatever the blood or affinity relationship was, the victim in this case testified, her sworn testimony was that she thought of the defendant as an uncle. He came to her house, he let her in, he went for a hug, and then her testimony was he put his hands on my buttocks. Now, anything we want to characterize as to whether he pinched her, whether his hands were just resting her, that's all kind of editorializing on what was testified to, which was that he put his hands on her buttocks for 20 to 30 seconds. That, in light of the fact that he told her you look sexy, is sufficient for a reasonable jury to conclude force or coercion was used.
So Mr. Kegaris seems to argues that we need to equally look at the victim's actions, and he points out the cases in Michigan, where one of the victims turned away, and in this particular case, the victim did nothing, and so are we going to give any credence, importance in how the victim reacted? And the suggestion, if she enjoyed it, does that mean that there's no force or coercion in reference to the CSC 4 statute?
Your Honor, I think the reaction of the victim, I'm not saying it's our position, it is the reaction of the victim is not dispositive one way or the other. It is worth considering in the totality of the evidence. I would note that resistance is not required under our CSC statutes, and so the victim is not required to actively resist. I believe in the case that was cited before, where a hand was where the Michigan cases where the hand was placed on the underwear and then withdrawn when she turned away, that was sufficient to say that there was no CSC. However, this was not a case where the defendant ever pulled his hands away from the victim. I don't think the victim need actively resist, especially when this case, the evidence needs to be construed in the light favorable to the government, and there's ample testimony from the victim that she was shocked and scared and didn't know what to do to explain why she may not have actively resisted in this case.
So I referred to the Michigan Court of Appeals case, People versus Whittam, and trying to see, what's the standard, so we can try and have some standard that the trial courts in providing guidance would be guided. And the language that I had that kind of intrigued me was where the court held that the actor's force need only be sufficient to induce the victim to submit to the sexual act, or to seize control of the victim in a manner to facilitate the accomplishment of the sexual act. And then this language that follows, without regard to the victim's wishes. And so in applying that as standard, without regard to the victim's wishes, and the focus is more on what the defendant did to seize control in order to accomplish the sexual act. What's your take in reference to that standard, if we were to try and adopt some standard where there can be some uniformity in trying to apply the various facts to the standard that we may wish to announce?
Your Honor, I think that standard could be applied to this case and have the jury's verdict upheld, and I do think that would provide some consistency. One thing, my reading of Tenorio is that while Tenorio specifically referred to sexual penetration, not sexual contact, it did say whatever force or coercion needs to be more than just that force inherent in the act itself, and sufficient act to seize control of the victim. I think given the size disparities, the fact that this touch of the buttocks occurred while this much larger man was hugging the victim, effectively constraining her victim, or a reasonable jury could have concluded that.
So
that
if we were to not consider with the language without regard to the victim's wishes, so if that was to be adopted, would that be inconsistent with the Tenorio standard that you just referred to, that it has to be more than the force more than just to accomplish the sexual act?
Your Honor, with the court's indulgence, could you repeat the standard?
Sure.
From
I'm saying that, you know, in Tenorio, you said that the standard there was that the force used has to be more than just accomplishing this the sexual act in order to constitute force or coercion. You know, setting aside there was if that's the distinguishing point, that's a sexual penetration case as opposed to a sexual contact case here. Whereas here in this People versus Wood, this Michigan Court of Appeals case, it says that, you know, the force that is needed is only that sufficient to seize control of the victim in a manner to facilitate the accomplishment of the sexual act, which seems to be that, you know, it's just what's sufficient to accomplish the sexual act, then without regard to the victim's wishes. And I'm asking if that standard would be inconsistent with the standard in Tenorio, that you have to have more than just the force to accomplish the sexual act. And here it seems to be that I don't know if it's if you can say they're identical, but in terms of seizing control in order to facilitate the accomplishment of the act and not look at, you know, how the victim or what her wishes may have been, whether, you know, in terms of her reaction to the sexual act, that's not a that's not a I don't know if you can say an overriding factor, but it seems that in the overall scheme of things, that's not the focus.
Yes, Your Honor. I think that definition, force needs sufficient to seize, accomplish of act, would be consistent with this court's prior holdings in Tenorio and provide perhaps a little bit more. I don't know that without regard to the victim's wishes, I mean, I think consent would still be offered as a defense, although while it's not really briefed, consent is kind of a challenging issue in the facts of this case, where we have a 14-year-old victim. And while it's not charged that way, I don't know that consent would have even been available as a defense for the defendant. Your Honor, may
Yes.
go
What
on.
about the fact that the force in this case that was other than the force inherent in making the contact was not just the hug, but the actual movement down to the buttocks?
Yes, Your Honor, that would also be correct. One of our challenges reading Tenorio is it doesn't really say what quantum of force is necessary beyond, but that certainly would be more force than that required to the touching of the buttocks itself being this sexual contact. Moving from a hug down to that position would certainly be actual force and an application thereof. Moving back, I think while I think there's certainly ample evidence of actual force being used, I do think that the most obvious way that force or coercion was used here is under the surreptitious approach. The surreptitious approach, the fact that the defendant entered knowingly through the front door and announced his presence, that's not the standard for surreptitious approach. As this court wrote in the Ehlert decision, surprise is not limited to circumstances where the victim is unaware of the perpetrator's presence, and it includes circumstances involving the perpetrator's surreptitious approach. And so the fact he was able to essentially gain access to the victim here by going in for a hug under some guise of family courtesies and pleasantries, and use that as an opportunity to effect the sexual contact, which is putting his hands on her buttocks. And under our statute, it does not matter that whether his hands were inside or outside her clothing. Sexual contact includes clothing over the intimate parts, and so that would be sufficient as well. But returning to the actual the use of actual force under the first enumerated example, when the actor overcomes the victim through the actual application of physical force or physical violence. Again, I think as we've discussed more, given that there was more than just the actual placing his hands on the buttocks, there is no specific testimony as to what he did with his hands. There's no testimony that he pinched, but there's no testimony that the hands remained static and did not pinch. There's no testimony that they were merely resting there. That in concert with the hug and the movement of hands, those are all sufficient to gain control over the victim and to constitute the use of actual force. Now, Your Honor, if I may now turn to the unenumerated example, as this the totality of circumstances and that this relationship is inherently coercive. There are no enumerated inherently coercive relationships under force or coercion, except for the use. I believe there's an enumerated example for a medical provider. But in the Tenorio decision at paragraph 20, this court said that under the totality of circumstances, there are a number of factors to be considered, and they include, as this court knows, the respective ages of the victim and the accused, the respective mental and physical conditions, the atmosphere and physical setting, and the extent to which the accused may have been in a position of authority, domination, or custody, and whether the victim was under duress. While the facts in Tenorio may have involved two grown adults surrounded by people, those are not the facts here. This is a 14-year-old girl. Her uncle was coming over. Whatever the blood or affinity relationship was, she considered him an uncle and somebody with enough authority in her life that she should open the door when he was trying to seek access to the home. He was much larger than her, or at least the jury could have seen their relative sizes. He felt he had enough control over her that he could tell her not to tell her father. And she was shocked by what occurred and felt isolated. And so under those facts, we think that this is also an appropriate case for the court to find one of our first unenumerated examples of force or coercion, given the totality of the circumstances and the relationship.
I think an additional factor is just Stories pointed out that he kissed her inappropriately. When you add that to all the other factors that you have listed, then I think that emphasizes the circumstances in reference to
Mhm.
that this was not something that was welcome.
Yes, Your Honor. Your Honor, in closing and pending any further questions from the panel, our position is that that there is sufficient evidence in the record of force or coercion under a number of different methods enumerated or not, and given all the facts and circumstances and evidence, weighing all this evidence in the light most favorable to the government, there is evidence of force or coercion, and the verdict of the jury should be sustained. And pending further questions, I will defer the remainder of my time.
All right. Justice Merriman, any questions for Mr. Jelly before I have Mr. Kegeris close?
No, thank you.
All right. Mr. Kegeris, you may close and conclude your arguments.
Thank you, Mr. Chief Justice. Just briefly, I would like to talk about the inappropriate kiss, as Your Honor has indicated. Now, it did come out during testimony during trial that it was a beso, kiss. I know there have been times where it is a sometimes you do miss. And it wasn't something that that there was testimony on. This was a long kiss, any kind of intimate kiss or anything of that nature. It was testified to by both parties as a beso or kiss on the cheeks. Going back also to not tell the father, like I stated earlier, this had been a very contentious relationship that had come out during testimony during trial, that they didn't really get along with each other. And so not to tell the father could mean don't tell that we're talking. Don't tell that you're talking to me because your dad doesn't like our side of the family. There was a deterioration of that family dynamic, that whatever it was, it didn't end well. And so your honors, just to go back a little further, they talked about the defendant never pulled his hands away, never did anything like that. And that could be because the alleged victim didn't say stop, didn't swat his hands away, didn't go back into the house, didn't do anything that was like in the Michigan cases.
But Attorney Kegeris, do we judge a crime by what the victim does or what the actor does?
No, Your Honor. We don't judge a crime by what a victim does or doesn't do. But according to the Michigan appeals cases, there are the issues of the actor, the victim doing something that says no, don't do this, and when they shove it away, and then as in the Patterson case, I believe I talked about earlier, where the defendant put his hands on the underwear, the victim turned away, shoved his hands away, and then he stopped. And so that wasn't seen to be a fourth degree CSC or a CSC. Now, as for the Tenorio case, there is a lot in that case about force or coercion, and that what this court found was that that in that situation, there wasn't force or coercion. And that is much more than what we have here on where the defendant is resting or not pinching, not doing overt acts of pinching or grabbing or rubbing or things of that nature that is in the Michigan Court of Appeals decisions that they
But
still.
Tenorio was a third-degree CSC with the sexual penetration. It was not a sexual contact case. Here, we're the fourth degree. And, there is a definition of sexual contact and a definition for sexual penetration that's contained in 9.5 GCA 2510.
Yes, and I do understand that situation, and it's just I do understand that it is a different third degree CSC compared to what we have here, and we just don't have anything on the fourth degree to guide us at this point, and so this is something that we need to come across so we can get guidance on how to go forward with this. And right now, Tenorio is one of the ones that we can use as guidance until something is settled on the fourth degree CSC.
All right, if there's nothing further, Mr. Kegris, we thank you, counsels, for your arguments this morning. The court will take the case under advisement, and the court now stands adjourned. Good day.
Thank you, Your Honor.
Thank you.